Hello everyone, welcome to Legal Darshan. In today's video, we are going to talk about A.V. Dicey's rule of law. So, the concept of rule of law was first discussed by Justice Coke and later theorized by A.V. Dicey in his work. All right, so we will go into the intricacies of what rule of law is and what A.V. Dicey has talked about rule of law. All right. Now, when we talk of rule of law, there are two terms that come to our mind. All right. Now, these two terms are very similar when we hear them. They are very similar. If one wants to construe the meaning, it can be said that these two are similar also. But there lies a difference. Rule of law means that everybody is governed by law, law is supreme, and everybody is subject to equality before law. Everybody is equally protected before law. This is the basic meaning of rule of law. So, the idea of rule of law basically enshrines the objective that in a system where there is rule of law, law shall always be supreme and not a normal law, not a law which can be arbitrary, but a law which promotes equality, which promotes public good, which does not compromises on human rights or individual rights of any person. So nobody, when we say nobody is above law, we are talking of rule of law. When we talk about rule by law, it is negative manifestation of lawmaking. It has a negative perspective. So in this case, this law is made by somebody who is men or who is people sitting in the sovereign power. Now when we talk of rule by law, it necessarily means कि जो भी law लिखा गया है वो follow किया जाएगा without even checking its arbitrariness, without even checking its abuse, because it has been laid down by people who are the lawmakers. This will be followed. So somebody is sitting in the superior authority and is making laws for us. And if we are following those laws, if those laws are being followed in the society, being enforced in the society without checking for humanitarian or human rights ground, then that law can be rule by law. So in rule by law, the political superior or the people in power, they have discretion also. So they may exercise discretion, which is harmful, which may be harmful, not always harmful, but may be harmful. Anyway, when we come back to our rule of law, we are going to discuss the A.V. Dicey's model. But before we start the discussion on his theory, on his principles, we need to understand that why rule of law exists. Why does A.V. Dicey's propounds this model? A.V. Dicey talks of rule of law. So in A.V. Dicey, what happened is A.V. Dicey's theory came as a response to French law, droit administratif. So in France, the law is itself divided into two branches. One is the public law, another is a private law. So your administrative law, droit administratif, is a branch of public law which gives the discretion to officials to exercise discretion while exercising their powers. Now, A.V. Dicey was basically threatened by a lot of powers, a lot of discretionary powers being given to administrative, and therefore he brings out his model and says that rule of law should prevail in any society, not what administrative says. So when he is talking about rule of law, he is propounding three principles, three doctrines. First one is supremacy of law. Second one is equal protection of law. And third one is predominance of legal spirit. predominance of legal spirit. We will discuss them one by one. So basically, supremacy of law. I usually, when I do this topic with students in person, when I talk about this topic with students in person, I always ask them what is the meaning of these two terms. Let aside two terms. This first term, what do you understand by supremacy of law? So various perspective comes into the picture, but sometimes we are confused within these two, what these two terms distinctly means. They are correlated, they are mutually inclusive, but this particular doctrine says that law prevails in every circumstance. Law prevails in every circumstance. Whatever law says, it will be supreme. Nobody shall be above law. Here it means nobody is above law. Okay, so a manifestation of this first doctrine, supremacy of law, is that nobody is above law. Law prevails over every circumstance. But when we are speaking of equal protection of law, we are necessarily talking of the protection the law grants. So law grants the protection equally. Here we are saying nobody is above law, but here we are saying that law protects everyone equally. All right, so whether you are a prime minister, whether you are a member of parliament, whether you are an MLA, whether you are a school teacher, whether you are a college professor, or you are a civil servant, or you are a housewife, homemaker, or you are a married daughter, or you are a unmarried daughter sitting at home, working somewhere, working in an MNC, or doing advocacy, or you are a sitting judge, the protection of law extends to everyone equally. All right. So, law is going to protect everyone equally. This is the second doctrine which has been laid down by A.V. Dicey. Now, the third doctrine is this equal protection of law is read together with equality before law. Equality before law, that law treats everybody equal. Equal protection of law is a manifestation of equality before law. So the doctrine is, second doctrine is basically equality before law, and its application extends to equal protection of law. Now, when we talk of the third principle, which is predominance of legal spirit, in this it is saying predominance of legal spirit, we are talking of judicial actions. So basically, A.V. Dicey is saying that law is supreme, but how do we apply it in spirit? So whatever the judicial scrutiny says, whatever the judicial action says, we are going to apply that so that the legal spirit should be predominant in our society. So basically, your third principle can be said to be an application of the first principle, because here we are defining that law is supreme. But how are we making it supreme? It is by the judicial precedents or judicial actions. Now, when I am talking of A.V. Dicey's model, we may relate it to one of the theories of jurisprudence that Harlow and Rowling has proposed, which is the red light theory. So the model nearly resembles the red light theory model. The principles of red light theory model basically resembles rule of law given by A.V. Dicey, only on the specific point that judge made laws should prevail. There should be a predominance of those because it upholds the legal spirit, upholds the spirit of law. Now, these three laws, as I was discussing earlier also, these three laws A.V. Dicey has propounded, it has been propounded as A.V. Dicey was basically threatened by abuse or arbitrariness that may happen. So the whole theory is premised on the threat of these two terms, which A.V. Dicey has suspicion of administration to be doing, right? So to prevent arbitrariness, to prevent abuse of power, we need rule of law. This is the underlying premise of rule of law as propounded by A.V. Dicey. Moving on, let's now discuss how do these three principles have relevance in India. supremacy of law, equality before law, and predominance of legal spirit. So your supremacy of law can be attributed to Article 13, not directly, but maybe indirectly, because it upholds constitutional morality and fundamental rights. Constitutional principles are upheld under Article 13, which says that any law being in derogation to the fundamental rights shall be null and void. So here we are upholding the supremacy of law because fundamental rights is whatever your preamble also reflects, and the constitution is the law of the land, and preamble is an essential ingredient, it is an essential component, it is the soul of the constitution. Therefore article 13 is a manifestation of the first principle of law. When we talk about equality before law, we are referring to Article 14 because it says equality before law and equal protection of law to all the persons, all the people in the country. Now, there is this one case in which it was held that equality is antithetic to arbitrariness. Okay. Equality is antithetic to arbitrariness. This is the case of E.P. Royappa. Okay, so E.P. Royappa, in this case, it was held that equality is antithetic to arbitrariness. So not only the constitutional provisions, but also the judicial pronouncements are aligning with the idea that has been given by A.V. Dicey. When we talk about predominance of legal spirit, we are basically relying on the burden, relying on the not on the burden, relying on the duty that has been discharged by the courts since time immemorial, that is still being discharged. And therefore, here we can relate this particular principle to free and independent judiciary, which will further link it with the idea of separation of powers, which is also a fundamental principle, which is also a basic structure doctrine as laid down in the case of Keshwanand Bharati. Now, also, there are several judicial pronouncements which are inclined with what rule of law says. So, we have Keshwanand Bharati, the famous 13-bench judgment, Keshwanand Bharati versus State of Kerala. We have Maneka Gandhi, which upheld the procedure to be just, fair, and reasonable. Maneka Gandhi versus Union of India, 1978, which overruled A.K. Gopalan. All right. Then we have minority verdict of Justice H.R. Khanna in ADM Jabalpur case, which has also upheld the idea of rule of law. Then further, we had the idea of free and fair elections as an essential feature of rule of law and an essential feature of a good democracy, which was held in Indira Gandhi versus Raj Narayan. Now, these are the few classic examples. There are many more examples which are upholding the spirit of rule of law in the in alliance with the Indian Constitution. But however, these few were the landmark judgments that have been extracted out for this particular topic. Now, like every theorist, every model that has been proposed in the field of law or any other field, there are always criticism to the model, because that's how the academics develop, that's how the literature develops. So Sir A.V. Dicey's theory was also subject to criticism, and one of the biggest criticism of the theory was that A.V. Dicey put a strict no on administrative discretion. But when you put a strict no on administrative discretion, your administration cannot flourish. So therefore, your governance is ruptured, your governance can fall apart, and which is not good for a healthy society. So to exercise To exercise power and to exercise law and making law and order, we need to give certain kind of discretion. Now, if for example, I I bound a police officer by certain rules that he cannot carry investigation, he cannot carry in investigation by this XYZ modes, but for few cases those XYZ modes are necessary. For few cases we need to apply those XYZ modes. When we are not giving them the discretion, when we are not giving them the power to exercise those modes, the inquiry, the investigation will ultimately be hampered, and the purpose of serving justice will also be delayed, or it will also be ruptured. That is why we need to give some kind of discretionary power to the administrative authorities so that there can be smoother functioning of law. All right. I hope the concept of ABDIC is clear to you. The principles are clear to you. How they manifest in Indian law is clear to you. This was a short video. It was a short lecture, a summarizing lecture on what rule of law is, what are its essential ingredients as propounded by Sir A.V. Dicey. For any more topics, any more doubts that you may have, while you are studying law or while you are preparing for any entrance exams, you may write to us at legaldarshan@gmail.com. This is our ID, email ID. I have written it for your reference here. And you may put your feedback, suggestions, or any queries that you want to convey to us on this email as well as in the comment box below. Thank you everyone for staying tuned with us. Please keep watching Legal Darshan.